Hello friends, let's continue and conclude our discussion on the NP Ponnuswami case, the election law case that we are discussing here on the Supreme Court Historian YouTube channel, decided by the Supreme Court of India on the 21st of January 1952. The case, as we saw, emanates because of the wording of Article 324 Clause B, which talks about election petitions which can be presented to such authority and in such manner as may be provided for by any law made by the appropriate legislature. And Mr. Ponnuswami argued that the election petitions refer to the word election in a very narrow sense and not in a broad sense. The court was, of course, of the opposing view. The narrow sense, according to Mr. Ponnuswami, that should be considered as the definition of election, implied only the final and actual selection of the candidate, the day of voting and the announcement of the result. The wider sense, argued by the returning officer and the government of India, and indeed accepted by the Supreme Court, was that the election includes everything that goes along with it, the entire conduct of the proceedings, right from the announcement of the election date and the filing of nominations, scrutinizing of nominations, withdrawal and rejection of nominations, the model code of conduct by the campaigning individuals and parties, and so on and so forth. To substantiate this particular interpretation, this particular wider sense of the word election, the Supreme Court referred to an article which appears a little before 329, the first article in this part on elections, that is Article 324, Clause 1. Clause 1 defines, creates the Election Commission, this entity that we are so well aware of and well versed with. The title of the article is Superintendence, Direction and Control of Elections. And what all comes under superintendence, direction and control? Basically everything. The superintendence, direction and control of the preparation of the electoral rolls for and the conduct of all elections to parliament and to the legislature of every state, and of elections to the office of president and vice president, shall be vested in the election commission. All that is fine, but the reliance was kept by the Supreme Court on the phrase the conduct of all elections, not just the counting of votes or the polling of votes, but the entire conduct, which was to be superintended and directed and controlled by an entity created by this article known as the Election Commission. This, according to the Supreme Court, points to the fact that the framers, the founding fathers, the Constituent Assembly members intended the term election to encompass everything that went along with it and not just the final date and a result of the election. Another provision, a statutory one, relied upon by the Supreme Court to arrive at this conclusion was there in the Representation of the People Act 1951 itself. We have already referred to Section 81 of this enactment, which talks about the election petitions and before whom and when can such election petitions be filed. And it also mentions that the grounds on which the election petition can be filed are found in Section 100 and 101. And when we look at Section 100, we will notice these are some of the grounds that are given over there. One of the grounds for filing an election petition, which if succeeds the election will be declared void, is that the returned candidate was found to be not qualified or was disqualified on the date of the election result. The returned candidate, which means the candidate who won the election. If a candidate who did not win was found to be not qualified, then it is anyway rather pointless and unfructuous to pursue that matter, because anyway the election result has not gone in that candidate's favor. The second ground, that a corrupt practice was committed by the returned candidate, once again refers to a returned candidate having involved himself in corrupt practices. The third ground is any nomination was improperly rejected any nomination, not just that of a candidate that claims to have been ahead in the opinion polls or something like that. If any nomination has been improperly rejected, that can be a ground for declaring the election void. Further grounds are also given that the result has been materially affected by improper acceptance of a nomination, or improper reception of a void vote, or improper rejection of a valid vote, and so on and so forth. But the most important ground, as far as our current discussion, as far as this case is concerned, is the one that I have underlined over there. Ground number 3, any nomination improperly rejected. An improperly rejected nomination is a valid ground for filing an election petition. That is what section 100 along with section 81 is saying. Section 100 is basically telling us that filing nominations is therefore a part of the entire election process, and that can be governed by only an election petition, and that is a sufficient enough reason to widen the scope of the word election to include all of these steps, including any corrupt practices or any disqualifications or any improper acceptance of nomination or any improper rejection of nomination, which according to Mr. Ponnuswami was the case over here in his nomination nomination, which was rejected by the Namakkal constituency's returning officer. That particular situation does fall under section 100 of the Representation of the People Act 1951. Therefore, it widens the definition of elections. The word election therefore has a wider scope, and therefore Justice Fazil Ali concluded in his opinion, the one which the other 5 judges accepted to, that elections should be concluded as early as possible. Therefore, all controversies arising out of them should be postponed till after the elections are over, so that the election proceedings may not be unduly retarded or protracted. If any irregularities are committed, they should be brought up by an election petition and not be made subject of dispute before any court while the election is in progress, while the entire conduct whose superintendence and direction and control is being done by the election commission, while that entire usually month-long process is taking place, there can be no dispute brought before any court. The right to vote or the right to contest in an election is not a civil right, but it is a creature of statute, and it therefore must be subject to the limitations imposed by that statute. And this is a very crucial point over here. When we study the Constituent Assembly reports, the discussions held by the founding fathers in the Constituent Assembly, and if not that, when we read Granville Austin's brilliant book, Cornerstone to a Nation, in both of these we come across the discussion that the founding fathers had about whether the right to vote should be enumerated as a fundamental right, and they decided to not include it as a fundamental right but instead as any other statutory right. And here then is the reason behind that decision, that if it had been a fundamental right, then of course it would always be the subject of some petition or the other before the High Courts or the Supreme Court. It was therefore a conscious, well thought out, highly analyzed decision to conclude that the right to vote should be a civil right, a statutory right, and like any other statutory right, which is a creation of a particular statute, then that right will be subject to the limitations imposed by that creating statute itself. Therefore, all the 8 high courts that had concluded, that had opined that they lack the jurisdiction to pass writs in election matters, all of those 8 high courts were correct in the opinion of Justice Fazil Ali and this 6-judge bench of the Supreme Court. It must be noted over here that 8 different petitions were filed before 8 different high courts, all with the same subject matter, that is, nominations were rejected and high courts had been approached for a writ of certiorari, and each of them had refused to interfere. Recalling that there were only 13 high courts in the country at this time, it was a, a problem of gigantic proportions. But the matter was settled, and settled very cleanly and nicely by the Supreme Court, that the writ of certiorari denied by the High Courts was indeed the right approach, that the Supreme Court would also deny this particular writ, and Mr. Ponnuswami and the 7 other candidates must await the election results and then file election petitions before the statutory authority. This concludes our first discussion of an election law case, N.P. Ponnuswami versus Returning Officer Namakkal. The videos have been included in a separate playlist for election law as well as for jurisdiction jurisdiction cases, but I am a bit wary of including it in a separate playlist for interpretation of statutes. Basically, every case will have the Supreme Court interpreting some word or the other in some provision or the other of a statute or of the Constitution. So let's try to restrict the interpretation playlist to specific examples of the subject of interpretation rather than this wider scope or narrower scope. Anyway, enough of that. Hope this has been an interesting case for you as well, and I hope you will join me for our next discussion soon. Till then, take care. Bye bye.